Good afternoon, everyone, and thank you for joining this Ius Laboris webinar. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms of Ius Laboris. And today we have lawyers from Brazil, José Carlos Weil, Czech Republic, Cristina Nebova, Mexico, Ana Sofia Lascano, and Netherlands, Kathleen Derks. And then we have Gisela Alvarado, who will be moderating the session, and she's from our Spanish law firm, Sagardoy. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab that you can see below to send your question to us, and the panelists will answer as many as they can at the end in the dedicated Q&A session. You can, of course, also reach out to them via email after the webinar. Then regarding the slides, they will be available on our website along with the recording after the webinar. And we will be also sharing with the attendees slides and recording via email. I will now turn over to Gisela Alvarado from Sagardoy to moderate the session. And go ahead, Gisela, you're welcome to start.
Thank you very much, Alessia. Good afternoon, everyone. Today we are going to discuss relevant topics, and we will start with a reduction of maximum working time. Although we cannot yet say that there is a global trend to reduce working hours, there have been legal changes or at least internal discussions in some countries. While in Colombia and Chile, the reduction of the maximum working time has been implemented in 2021 and 2023, respectively, in Spain right now, there is a bill awaiting parliamentary debate and approval, which provides for the reduction of the maximum legal working time of 40 hours per week to 37.5 hours per week. Of course, this measure without implying any reduction in the employee's salary. Brazil and Colombia also have news on this front, and my colleague José Carlos will now analyze the issue from the Brazilian perspective.
Thank you, Gisela. In fact, we have in Brazil a kind of unique situation because working hours are provided for in the Constitution. Remember that Brazil was a military dictatorship until the 80s. So most of the social and employment rights are reflected in the Constitution to provide more reassurance that they will be observed throughout the years or throughout the future. The maximum number is 44, but for quite a while there have been discussions on whether we should reduce them to 40. In fact, what we see is that many sector CBAs, many sector collective agreements between unions and employers associations already reflect a maximum of 40. I can mention, for example, the IT industry in São Paulo has such provision in their agreement. And once it moves down, in fact, it's almost impossible to move up again. So I think we have a trend in certain industries. But the question is, will it become a final change or a formal change in the law? Well, I don't know, really. Last year, the Congress has engaged in some discussions. One of the proposed bills would mentioned that even 36 would be a desirable cap to working hours. However, there was a counter-strike in such debate raised by some important players in the industry, saying that Brazil has two challenges. We have one of the lowest productivity, industrial productivity in the continent. And we also have obsolete industrial facilities. So before moving down the number of working hours, maximum working hours, perhaps we should address such issues of productivity and having a more modern or up-to-date industrial facility. I don't think that we will be seeing, for political reasons, any immediate change in the law, maybe in the next couple of years, but not exactly this year. However, what I can tell you is that there is a growing number of unions that successfully obtain such reduction through collective agreements, which are, of course, enforceable, binding, and cover all industries and employees, irrespective of affiliation. So one way or another, we will be seeing 40 hours as the maximum numbers in the following years.
Thank you. Well, good morning, everyone, and good afternoon for those joining us from Europe. I am Ana Sofía Lascano, and it's a pleasure to be here today to talk about one of the most important employment law discussions happening right now in Mexico, as following up on this matter, the reduction in working hours. So the main goal of this legislative project is to establish a standard work week of 5 days with 2 full days of rest, reducing the legal work limit from 48 hours to 40 hours. It is important to mention that this is not the first time we've seen an attempt to reduce the working hours. In fact, several initiatives have been proposed in the recent years, but 2025 is shaping up to be the year where real progress is made. So what's different this time? Well, recent proposals have introduced a key element. This is the gradual implementation rather than the immediate enforcement. Currently, 5 constitutional reform initiatives have been submitted to the House of Representatives, all aiming to establish this new work schedule, while incorporating transition periods to ensure a smoother adaptation for both businesses and the employees. Unlike the 2023 proposal, this recent effort have sought to unlock the reform by including transition periods and even pilot programs to allow for a phased implementation. Some of the key aspects under this discussion include: first, the reform will take effect 1 year after approval, with additional 6-month period for Congress to adapt this change into secondary legislations. Then, the implementation will depend on the company size. For micro businesses, will be 3.5 years. For small businesses, will be 2 years. For medium-sized company, will be 1.5 years. And finally, for large corporations, will take 6 months. And also, a 1-year pilot program will be coordinated by the Ministry of Labor along with the Ministry of Economy to gather data, assess productivity, and then allow 180 days or 6 months for authorities to conduct roundtable discussions to define the transition strategy. So what's next? Well, in 2025, discussions will shift from theory to action. The conversation is not longer about whether Mexico will adopt this 40-hour work week, but rather how and when. So, looking ahead, roundtable discussions between lawmakers and employers, are expected to begin as soon as March, with the goal of concluding the implementation strategy probably this year in 2025. And well, for the next part of the presentation, I'll hand it over to Gisela for introduction. Thank you.
Thank you very much, Ana Sofía. Now let's move on to our second topic. As part of the growing need to balance family and working life, a number of countries have introduced new measures to facilitate this balance. While Denmark is planning minor adjustments to its maternity leave provisions in 2025, Poland has granted additional maternity and paternity leave to those parents of premature babies and to those who require hospitalization after birth. New paid leaves have been introduced in Mexico and in the Netherlands. My colleague Kathleen will give us some insights from the Netherlands.
Thank you, Gisela. And good morning, good afternoon to all participants. My name is Katelijn from the Netherlands, and with regards to the Netherlands, the Dutch government is preparing a new type of legal leave related to bereavement. Currently, the law only provides so-called short leave for exceptional situations, which can usually be taken to prepare and organize for the funeral for close relatives. This leave should be taken into consultation between employer and the employee. and it appears that many employers show to be quite flexible towards this leave, even without having formal legislation. Still, however, employees are now mostly dependent on the goodwill of their employers, and many employees do not know what to expect from their employers. Many feel forced to use their holiday balance, to call in sick, or to take unpaid leave to cope with the loss. And this lack of structure can create uncertainty, increase stress, and even strain the employer-employee relationship in the end. And that can lead to actual and prolonged sickness absence. So what may change? The bereavement leave legal proposal, and it's just a proposal still, aims to provide a statutory right to paid leave for employees with families with minor children, of whom a partner or child sadly dies. The leave covers at least once the working hours per week, so this means that full-time employees are entitled to at least 5 days of bereavement leave. And this would become a mandatory minimum standard, so employers may offer more, but cannot provide less. And pay should be continued, so the salary at 100%. Affected employees can take the leave at once, so they can choose, or flexibly from the day after the funeral, until 1 year after the loss. The bereavement leave cannot be deducted from any holiday balance, so that gives more certainty for the employees. How will it work in practice? Affected employees only need to notify their employer. They then must state the time of commencement and the estimated duration of the leave. If prior notification is not possible, the employee must notify the employer as soon as possible, the proposal says. Employers cannot deny the leave unless they can show a compelling business interest that outweighs the employee's right to take it. In other Dutch legislation about leave, this condition appears to be very difficult for employers to prove. So most of the times they have to give their consent. The government expects that creating a legal basis for bereavement leave, specifically aimed at working parents who lose a partner or minor child, will help improve support for grieving employees and promote sustainable employability in the workplace, as you said also, Gisela. It is possible that the proposal will still be amended. Having read the advice from the government, the advisory body already commented that the bereavement leave should not only focus on families having minor children, so it might be a broader focus when it's implemented, and we will of course keep you updated on the further developments. And if you have any question, please put them in the Q&A box. I will now give the floor to Ana Sofia, who will discuss the Mexican view on bereavement leave and on paternity leave.
Thank you. Well, following up on the proposal for implementing bereavement leave, this is another key employment right that has long been debated in Mexico. Today, employees not only have to deal with the emotional weight of grief, but also all the bureaucratic challenges of legal paperwork and while being expected to continue working. Despite this significance, bereavement leave is still not recognized under the Mexican federal labor law. However, this change is under discussion. On October 24 of last year, the Senate introduced a new initiative to formally establish paid bereavement leave, ensuring it becomes a guaranteed right rather than something left to the discretions of the companies. While the proposal is still awaiting debate, it represents an important step toward addressing this gap in employment rights. The initiative seeks to amend the Article 132 of the Federal Labor Law, which specifically outlines employer obligations in Mexico, by granting these employees at least 5 working days off in the event of the death of a parent, a child, a sibling, a spouse, or a domestic partner. Then, employees would then have up to 30 working days to provide their employer with the necessary death certificate. It's important to mention also that this isn't the first time in Mexico that we attempt to implement this bereavement leave. Actually, in 2016, the House of Representatives approved a similar measure for 3 days of paid leave, but it stalled before becoming law. Also, in 2021, another effort was made to guarantee 5 days of paid leave, but yet the proposal never reached a final vote. But now, with this renewed push, the discussion is back on table, and we may finally see a change in 2025. Additionally, bereavement leave isn't the only individual employment right on the table. Another major reform under discussion is the expansion of the paternity leave. Under this proposal, paternity leave would increase from the current 5 days to 20 days with full pay. Additionally, if there are any complications during the childbirth for either the mother or the baby, the leave could extend up to 30 days, provided medical documentation is submitted through the Mexican Social Security Institute. Although this initiative was approved in 2023, it hasn't moved forward in the legislative process. However, it remains a priority in the topic of the 2025 agenda. Now I will hand it over again to Gisela, who will take us through the next topic.
Thank you very much, Ana Sofia. Okay, so now let's move on to our next topic. Basically, in Brazil and the Czech Republic, new changes have been made in terms of employment security and worker protection. So, José Carlos, what relevant information can you give us from the Brazilian side?
Thank you, Gisela. It's in fact a very important change we have. For the first time, mental health has been incorporated into the regulations. Just so our public can understand, in Brazil, work health and safety is subject to regulations issued by the Ministry of Labor. They are called regulatory standards. They go by the acronym NR in Portuguese. We have 38 NRs in Brazil. Some of them are quite specific to certain work conditions, such as hazardous conditions or flammable materials, etc. NR1 is the most generic regulation. It addresses the employer's general obligations to identify, mitigate, and remediate risks in the workplace. Traditionally, those risks were all risks to physical health, but now the law has been, or the regulation has been amended last year. It will be in effect as of May 25th this year. And employers must now amend their own plans, there are mandatory plans, mandatory routines they must observe to also identify risks to mental health, mostly derived from moral or sexual harassment. In fact, this is somehow in line with a change we have seen 2 years ago when a new law was approved to include or to improve, in fact, prevention, investigation, and remediation of sexual harassment as part of making workplace safer, mostly for women, but for people in general. So what we see is that companies in Brazil must, for the first time, be prepared to identify something that is quite abstract. I mean, you can easily identify if you have risks with flammable or electric material, but how can you identify? How can you map? How can you prevent mental conditions, mostly derived from excessive work, harassment, etc.? So this is a huge change. I think that some companies have been, as part of their global well-being programs, addressing this. But now this has to be formalized and captured into official documents, official reports they need to keep and prepare, and of course, improve anytime that they see that there is room for improvement.
Okay, I suppose that was it for José Carlos for now. Hello, everyone. My name is Kristina Nehybová, and I will be speaking on behalf of the Czech Republic today. Good morning, good afternoon, everyone. in the Czech Republic, we are expecting quite a lot of changes in the area of labor law in 2025. The changes we will discuss today have not yet been approved, though. The amendment is still being discussed in the Czech Chambers of Deputies, and only after approval by the Chamber of Deputies, it will go to the Senate and then to the President for signature. So we do not know yet when those changes will be effective. We expect it will not be before the 1st of May 2025, probably more likely 1st of June 2025. Furthermore, the changes that I will present to you today are only the, let's say, most interesting changes. The proposed amendment to the Labor Code contains more changes. So now let's get to the points. Length of probationary period. The employer and the employee now can agree on a probationary period of 3 months for ordinary employees and 6 months for managerial employees. The maximum probationary period will, based on the new amendment to the Labor Code, be extended to 4 months for ordinary employees and 8 months for managerial employees. Furthermore, it will probably be possible to extend the probationary period during its duration up to the limits that I mentioned already. This is quite a big change because so far this was not possible. Regarding the next point, priority of cashless payment, payment of salary is now to be made preferably in cash at the workplace, as the current labor code states, unless the parties agree to a cashless payment. This is a very common provision of employment contracts. Most of the parties agree that the payment will be done through a bank transfer, not in cash at the workplace. However, now it is proposed that the cashless payment will take precedence, meaning that the parties will not have to agree anymore in the employment contract or some other agreement. The employee will still, however, be able to not agree to this, will be able to express their disagreement with this type of payment. Next point, payment of salary in foreign currency. It will be possible to pay salary in foreign currency, not only in Czech crowns, provided that the exchange rate has been announced by the Czech National Bank, and also provided that some other conditions are met. This might be quite a big or interesting change for some employers who are based abroad. However, there will have to be some connection to the foreign country. For example, the work would have to be performed abroad, or the employee would have to permanently live abroad, or the employee would be a foreigner, something like that. So there will still have to be some connection to this foreign country. Return to work from parental leave. Employers must now reinstate employees to their original job and workplace. We call it the original chair, if the employee returns to work after maternity or paternity leave. They will, paternity, not parental. They will now also have to reinstate the employee to the same chair, as we call it, when the employee will be returning from parental leave until the child is 2 years of age. So this will also be quite a big change, and the employers, the companies, will have to keep an eye on this, will have to keep track of when the employee is returning. The limits of fixed-term employment is the next point. At this moment, a fixed term can be agreed for a maximum of 3 consecutive times, and each time for a maximum of 3 years. This means that the longest possible duration of a fixed term is 9 years. There will now be, newly based on the new amendment, there will be no limit on the number of times an employee replacing employee on maternity, paternity, or parental leave can repeat a fixed period. However, the maximum duration limit of 9 years will still apply, but it will be probably more easy for employers to find a replacement for an employee who's going on maternity or parental leave, because now they will be able to prolong the fixed term period for more times. Performance of work on a parental leave. It is now not possible to have two employment relationships with the same employer with the same type of work. There will now be an exception for parents on parental leave. These employees will be able to enter into another employment relationship with the same employer with the same type of work as the one from which they are taking the parental leave. This is also quite common topic when an employee, for example, a mother on a parental leave, wants to still keep in touch with her work, wants to still keep working for her employer, but cannot because the different type of work would have to be agreed between the parties. So now this is expected to be changed. Then we have one quite controversial topic that caused some discussion in the Czech Republic, and that is work of children from 14 years of age. Minors can now work if they have reached the age of 15 years and have completed the compulsory school attendance, which is 9 years of primary school in the Czech Republic. Newly, according to the proposed amendment, children as young as 14 will be allowed to do easy work during summer holidays with the consent of their parents. As I mentioned, this caused quite a big discussion in the Czech Republic. It's a controversial topic, but it's quite expected to be approved. And last topic on this slide is prohibition of confidentiality of salary amounts. It is proposed that employers would be explicitly prohibited from restricting employees from disclosing salary information. For example, employers would not be able to prohibit employees from disclosing their salary to other employees. This is also quite common provision in employment contracts right now, even now it's not certain if the employer could actually enforce this. These confidential clauses are very common, as I mentioned. However, newly, those practices would be expressly prohibited and violated. Violation of this prohibition could carry a fine. So this is also quite a big change that the employers have to keep an eye on, and it will be necessary for them to revise the employment contracts that they are giving to employees. That is it for me for this topic. So now I give word back to Gisela.
Thank you very much, Christina, for such relevant information. Now, in terms of employment status and misclassification risks, Katalin, what should Dutch companies be aware of in 2025?
Thank you, Gisela. Well, they should be aware of quite something, and that's that since January 2025, the employment landscape in the Netherlands has indeed changed quite drastically. And that's because the Dutch tax authority has now finally resumed enforcement of rules against false self-employment. And this marks a major shift in the employment landscape in the Netherlands. And in order for me to be able to explain the impact of this change, especially for participants outside of the Netherlands, let me first provide some context and background. In the Netherlands, we roughly have two types of labor contracts. Firstly, we have the classic employment agreement, which is the so-called ticket to the applicability of employment law and the employees' protection that go with it, like minimum wage, for example, holiday allowance, mandatory paid holidays, paid sick leave, which is in the Netherlands during 104 weeks, so 2 years, and dismissal protection, which is in the Netherlands quite strict because it means that the employer needs to obtain prior approval to terminate an employment agreement, and the approval will only be given if the employer has a reasonable ground and it appears not possible to redeploy the employee. Such employment agreement is usually favorable for employees from a protection perspective, but it also imposes financial obligations on employers, like the obligation to pay payroll taxes and social and employee insurance contributions to the tax authority, and the obligation to continue paying the salary during this first years of illness. So that's why sometimes both employee and employer have an interest in being self-employed. And that takes me to the second form of contract, and that's the contract for services, or also the contractor agreement. In this case, the worker, so the contractor, is considered self-employed. The contractor is independent, or should be, and he should be an entrepreneur who does not work under the authority of any other party. As a result, employment law protections don't apply in this case, and there are no obligations relating to payroll taxes or social security contributions. Instead, they are responsible for their own taxes, such as income tax, VAT, etc. The main difference between an employment agreement, as we know it, and contractors' agreement is usually the employer's authority element. In the case of an employment agreement, that is present, so there's authority. In the case of a contractor agreement, it's absent. Whether it is present or absent in a specific case or employment relationship is frequently subject of litigations, especially previous years. In the Netherlands, in the last years, the amount of workers that present themselves as contractors has increased significantly. Over the last decade, self-employment in the Netherlands has even nearly doubled, from 900,000 in 2014 to 1.8 million in the end of 2024, which is almost 10% of our entire population. We're not that big in our country. It is estimated that at least a significant part of the contractors in the Netherlands are in fact falsely self-employed. False self-employed means that while both parties assume the work is performed under a contract for services, so lacking this employer's authority, or while the worker presents themselves as self-employed, the real self-employment is lacking in practice, and the employment relationship therefore should classify as an employment agreement having all these protection rules. One reason for this has happened is the lack of enforcement by the tax authorities. In the Netherlands, this authority is responsible for controlling false self-employment and can reclassify employment relationships. False self-employment has long, at least since 2016, been explicitly tolerated on a large scale. There was explicitly no enforcement action by the tax authorities. And this authority could issue warnings, but only imposed actual sanctions in clear violations, which were not always the case. And this made it fairly easy for workers to present themselves as contractors and for companies to keep hiring them. One of the main reasons for the lack of enforcement was that the rules within the tax authority did not match anymore the modern way of working and the ways in which employers' authority can manifest. For example, due to the rise of remote and platform work, the element of authority changed. Another reason is that was in practice not clear enough how to distinguish between a contract for services on the one hand and an employment agreement on the other hand. There was much litigating about it in order to get more clarity. Over the years, this problem has gotten bigger and bigger, and the consequences have shown. This led to growing concerns about worker exploitation and unfair competition between employees and contractors. In addition, there has been important Supreme Court rulings on how the distinction could be made and should be made, and which factors are at least important when making the assessment of a labor contract. For example, we had the Deliveroo ruling. These developments have led to the Dutch government to prepare several measures. And this is reflected in particular in the following two measures. The first one, per the 1st of January 2025, the tax authority has resumed regular enforcement. So that's an important change. The tax authority now actively investigates false self-employment in all sectors and can impose sanctions such as correction obligations and fines. 3 key limitations, however, apply. Although in principle the tax authority can impose sanctions retrospectively, it has indicated it will not do so beyond the 1st of January 2025. So that gives a bit of certainty for companies. Only in very obvious violations, a retrospective period of 5 years applies. A transition period, that's the second one, of 1 year applies during 2025. So the tax authority will not yet impose fines if the employer can prove they are taking steps to mitigate false self-employment within their organization. As such, in 2025, some flexibility is still expected from the tax authority. This will lapse then as of 2026. As the tax authority is facing ordinary capacity problems, as there is a problem worldwide on capacity problems, it is expected that the initial enforcement will mainly focus on high-risk sectors. And in the Netherlands, these are, for example, healthcare, education, and childcare. The effects of the measures are already showing. For example, we see that employers are moving away from contractors, even in legitimate cases, out of fear of legal risk. Employers are shifting their staffing strategies and are now looking for other ways to use flexible staff to overcome the capacity problems in the labor market, which are shown widely, but specifically in the high-risk sectors in the Netherlands. We also see this reflected already, within a few months then, in the registrations of self-employed workers of the Chamber of Commerce. This is also shown in the figure on the slide. You can see a dip as from January this year. Then the second measure. The second measure is a proposed legislation and therefore only still a potential measure. It concerns a legal proposal that aims to further clarify employment relationships and the definition of employer's authority. The proposal was originally planned to come into effect as per the 1st of January of this year, but that has not happened due to the elections in the Netherlands. In the meantime, the government's advisory body has been very critical to this form of the proposal, as it remains hard to define the meaning of an employer's authority up front, and the proposal is considered only a written confirmation of the current status of case law, which has increased during the last year. Also, the Supreme Court has filed a new ruling only last Friday in one of the Uber driver cases, which has led to further criticism regarding the proposal. If the proposal will still come into effect, which I frankly question, this is expected to happen in 2026, but further details are unknown at this moment. Both measures, resumption of enforcement by the tax authority and the proposal, already have and still may highly reshape the Dutch labor market, especially in sectors that have always relied and even still rely on contractors, such as health and childcare. It's important for both employers and workers to be aware, therefore, of these developments and adapt accordingly. Again, any questions you're having may be asked in the Q&A box. And I will now give the floor again to Gisela to introduce the last topic of this webinar.
Thank you very much, Kathleen. Okay, so now we come to the last but not least topic. My colleague Christina will give us an insight into the recent changes to dismissal procedures in the Czech Republic.
Yes, I will just correct a bit. We don't have the changes approved yet. They are still in the parliament. However, we expect most of them to be approved. So let's get to it. The first topic is the length of the notice period. Currently, the notice period under the Labor Code is 2 months. The notice period can be agreed longer, but not shorter, and must be the same for both the employer and the employee. It is now proposed that the notice period should be reduced to 1 month for certain termination grounds. This would include termination for failure to meet legal prerequisites or requirements of the employer, unsatisfactory performance of the employee, breach of duty by the employee, and a breach of medical treatment regime during the sick leave. Another topic is duration of the notice period. In the Czech Republic, the notice period now starts on the first day of the month following the delivery of the notice. This means that if the notice is delivered, for example, on the 26th of February, and then the notice period would start on the 1st of March. In the future, the notice period should start from the date of delivery of the notice, meaning that if the notice was delivered today, the notice period would indeed start on the 26th of February, and the employment relationship would end on the 26th of April, so in 2 months. Another topic is the time limits for giving notice for breach of duty. This might be also very interesting. An employer can now only give notice to an employee for breach of duty within 2 months of becoming aware of the breach, but at the same time within 1 year of the breach occurring. These time limits will now be extended to 3 months and 15 months. Severance pay for work injuries and occupational diseases. Until now, severance pay in the cases of termination due to work-related injuries and occupational diseases has been paid by the employer directly from the employer's own funds. In the future, however, this severance pay, now it will be called one-off compensation for non-monetary damage, will be paid by the employer's insurance company. This means that the employers will save some funds, since this compensation will be paid by their insurance company. And the last topic that might be the most attractive to companies is termination without giving a reason. During the legislative process, a group of members of parliament proposed that employers should be able to give notice to employees without giving a reason, which is not possible at the moment in the Czech Republic, as I think in the most of the world. It would not be possible, however, to give notice without giving a reason to all employees. Some groups would be protected. Protected would be employees of pre-retirement age, meaning 5 years before retirement, pregnant employees, employees on maternity leave, paternity leave, and parental leave, and employees receiving a disability pension, meaning employees who have some disability. These employees, if they would be giving notice without providing a reason, they would be entitled to 2 times the statutory severance pay, meaning they would receive a 2 months severance pay if the employment relationship would last less than a year, 4 months severance pay if the employment relationship lasts at least 1 year but less than 2 years, and 6 months severance pay if the employment relationship lasts at least 2 years. This proposal would make it easier, of course, for companies, for employers to dismiss employees if they do not have a strong enough reason. However, this proposal is unlikely to have a sufficient support in the parliament, so we do not expect it to be approved. And that's it for me. Now I give a word back to Gisela.
Thank you very much, Christina. Okay, so 2025 will bring us many legal developments in the area of individual employment rights. And questions and doubts will certainly arise about their practical application. We will start by answering the questions that have been sent to us in the chat. Okay, so the first question is for Mexico, in particular to Ana Sofia, and it says, okay, Ana Sofia, it says, I understand that labor reduction is a priority on the 2025 agenda. However, is there an estimate on when they believe it will be approved in Mexico?
Yes, thank you, Gisela. Well, unfortunately, at this stage, there is not a definitive timeline for the approval of this reform. However, as it mentions, it remains a key priority for the 2025 legislative agenda, and discussions are expected to follow up in the coming months. This process will involve roundtables and formal negotiations between the lawmakers and business sectors and labor unions as well to reach a consensus in the final terms of implementation. This reform has taken longer than expected because first, it's a constitutional level reform, and it has been a continuing debate whether the reduction in working hours should be implemented immediately or gradually. But right now, this disagreement led to the introduction of multiple reform proposals, specifically 5 until now, and each with different implementation approaches. However, this year marks a turning point, and for the first time, there is a consensus on gradual implementation. The latest proposal, as I mentioned, include a clear transition period to adjust progressively based on their company size, and this makes it more likely than ever that this reform will move forward in the legislative process in the coming months. And well, as I mentioned, if this is approved, the reduction will take effect 1 year after the publication, with additional 6-month period for Congress to harmonize with secondary legislations. And well, also given the complexity of this gradual implementation, including the proposed different timelines based on the company size, the approval process may take additional time than usual, but the upcoming working groups consultation and legislative sessions will be crucial to determine the final details and timeline for this huge labor reform.
Thank you very much, Ana Sofia. Now we have some questions for Brazil. So, Jose Carlos, new regulation standard number 1 coming into effect from May 2025. Okay, is there an exception, or it applies to all employers, like even micro business? So, will regulation apply to all employers irrespective of headcount?
Yes, in fact, it applies to everyone. This is the generic regulation on employers' obligation to plan and keep documentation in good shape. There would be other regulations that would apply only to a sizable business, but this one applies to everyone. This applies across the board. Of course, that if you have a smaller business or a business with a limited number of employees, planning and anticipating possible risks would be easier. The more complex is the organization, the more employees you have, the more departments you have, the more sophisticated is the structure, the plan would be more complex. The thing is that every company should have proper advice, not only from a legal standpoint, but from an occupational health standpoint as well. I think that occupational and safety consultants, like occupational doctors and engineers, are still preparing. This is why the law gave the companies 6 months to adjust, or a little bit more than 6 months to adjust, because they know it's not an immediate or a change that could be immediately put into effect. I also expect that, even though the law doesn't say it, that in the early stages of this new regulation or expanded regulation, auditors will be a little bit more patient, and if they detect situations of non-compliance, they will give them a note, they will give them a warning to improve and not immediately apply penalties. But companies should not rely on that. This is just a contingency plan in case you need time to adjust, in case you need time to hire occupational health advice. But yes, it is applicable to every business in Brazil.
Many thanks, Jose Carlos. Also, in relation to this matter, we have another question. How can companies and HR in Brazil be prepared, or can be prepared, for an and R1, what would be your main tips?
Well, I think that there are two ways of addressing this. First, looking backwards, looking at the track record of possible complaints that the company got in the hotline. That would probably give a very good clue of where you have problems, where you have management issues in terms of managers being too aggressive or hostile towards their workers. Of course, looking at the litigation track, it would also help. Brazil is a very friendly place for labor and employment litigation. So looking backwards would also provide some guidance to the future. But one thing to keep in mind is that occupational health in terms of mental issues is part of a trend worldwide, not only in Brazil. I would say that most organizations would already have programs and trainings designated to improve well-being and hotlines to address employees' questions. I think that starting from such programs, but in case you don't have one, it might be a good idea to start. And from that plan that would be addressing the specifics of each company, prepare a monitoring and remediation plan as the law requires. But in any case, let me make it clear again, such documents, such occupational health documents, need to be prepared and approved by consultants, by occupational doctors.
Thank you very much, Jose Carlos. Now we have one question for the Netherlands. So, Kathleen, what would be your advice for companies to do now to ensure they are compliant and avoid sanctions regarding employment status?
I think this year, because the tax authorities are not imposing fines yet, is a very good year to assess whether your contracts are actually service contracts or that there might be employer's authority, because in that case it is an employment agreement and that's something different. So please assess the contracts and well, really use this year to check what it actually is, because if it feels and looks like an employment agreement, it might be an employment agreement. And the tax authorities will not look at the text of the contract. They will look at the actual behavior and all facts and circumstances. They will include everything in order to assess whether and to determine whether or not it's an employment agreement or a contractor agreement. So it's quite a good time to start assessing it.
Thank you very much, Kathleen. Now we have one question for Czech Republic. So, Christina, under the new rules, when does the notice period end if we give notice on 31st of July? But there is, just one second, but there is no 30th September.
31st September, probably. I understand. So as I mentioned, according to the proposed amendment, the notice period shall start on the date on which the notice is delivered to the other party and shall end on the date which is numerically identical to this date. However, if there is no such date in the month, then the employment relationship should terminate on the last day of the relevant month. Meaning, if we deliver the notice on the 31st of July and there are not 31 days in September, the notice period will finish and the employment relationship will terminate on the 30th of September.
Thank you, Christina. Now we have another question for the Netherlands. So, Kathleen, when is the bereavement leave to come in place?
Well, as it is still a proposal, the act, we don't know that yet, and it's not in the proposal. If it comes into effect, we presume that it will be with immediate effect, but for now it's still a proposal and it needs to be assessed by the House of Representatives first, and then the Senate needs to vote on it as well. So for now, it's still unsure when it will be implemented.
Thank you very much, Kathleen. Now I have one additional question from Brazil. So it's okay. So Jose Carlos, what happens if we have conflicting provisions about working hours in the sector collective bargaining agreement and in the employment agreement?
Very good question. In fact, this happens not only with working and contract, conflicting ones. The more favorable provision will apply, but in case of working hours, the smaller number will prevail. Meaning, even if the law stipulates that a maximum is 44 or maybe 40 in the future, or if the CBA provide it's 40, if the company by itself determines in the employment agreement a smaller number, that will be the new limit. So conflicting provisions will be determined by the most favorable one to the employees, meaning lesser working hours. If there are companies, in fact, that even if the CBA doesn't provide for a maximum of 40, they have spontaneously been applying 40 as a maximum. They cannot move up to 44 anymore because they have implemented as their own policy a maximum of 40.
Thank you very much, Jose Carlos. Now we have one question for the Netherlands. So Kathleen, would it be possible to share the list of criteria for employer to assess the contractor contract?
Yes, it's still derived from case law at this moment, but we can, of course, share it through email. Happy to do so. Yeah.
So thank you very much. Alessia?
Yes, thank you for all the questions. Thank you very much for having joined the webinar. Unfortunately, we are running out of time and our panelists didn't have enough time to reply to all your questions now, but they can reply via email. In our last slides, we have shared the email of each panelist. For any further question, they remain available. We have a variety of resources and insights on the cross-border employment rules on our website, so don't forget to check them out. And for more information on our webinars, you can visit the webinar section of our website to find all the past recordings and download the slide decks. And while you are there, also take a listen to our podcast called Talking Work, in which we talk about the world of work. And finally, I would like to thank everyone for attending the webinar and thank you to our panelists for their very interesting insights. And with that, this webinar will be now ending. Thank you and have a great rest of the day.
Thank you very much. Bye-bye.
Thank you. Thank you for joining.
Thank you all. Bye-bye.
Thank you. Bye.
Thank you.